it please the court, I'm Jeanne Tate. As this court recognized when they honored me with the Tobias Simon Award, I have long advocated for the rights of children, and I am here today to advocate for a child-centered approach to resolution of the issues before this court. And what that means is that we have strict time frames to prevent open-ended delays, that we provide certainty in the process to come to speedy resolution, and that we enhance permanency options for children. And I strongly believe that the narrow set of rules that are proposed to this court accomplish that objective, and they are consistent with due process.
The narrow view is that parents who are represented, who hire their own attorneys, would not have the benefit of the ineffective assistance of counsel provisions?
Justice, I disagree that these rules address that issue. There's been argument made in the briefs that these rules would prevent an attorney that was privately retained or a party that
You do not agree that if you hire your own attorney, you should not have that right?
What I'm saying, Your Honor, is that the rules do not preclude that. They don't address that because this court has not substantively determined that those individuals have a constitutional right to counsel. I disagree vehemently that that's what GB stated, and in fact your holding was very specific.
You're answering your question. Could you answer the question that Justice Quince posed?
Maybe I misunderstood it, but I do not believe that this court or the law in this state requires...
The question I really ask you is, we are looking at whether or not any parent, no matter whether they have their own attorney or have a court-appointed attorney, has the right to bring an ineffective assistance of counsel claim. Do you agree or disagree that any parent should have that right? I
disagree that a parent that retains a private attorney has the constitutional right to advance an ineffective assistance of counsel claim. I disagree that JB addressed that issue. I think this court very narrowly and carefully tailored that decision to specifically hold.
You support the narrow view.
Narrow view.
Okay.
Narrow view.
Okay.
Could you respond then to the those who believe that the entire basis or constitutional basis for this dispute is that there is due process necessary when the state begins to impact the individual citizen. Criminal cases, they've cited the criminal cases, and you agree, I would hope that in that area, whether you're indigent or whether you have a paying lawyer, a paid lawyer, that the ineffective assistance is an issue. You agree with that?
Absolutely, Your Honor.
And they argue that that's the underlying analysis, not some other analysis. And I would wonder out loud as well. I've been doing this job now for a number of years, and it seems to me is that at times paid lawyers are worse than no lawyer. And in this kind of situation, I'm wondering, or I have a concern with whether you can go out and find some lawyer on the street to pay him a few $100. Yet if you're indigent, you can have the very best, like the public defender system. And in the criminal context, the public defenders are as good or better than any of the lawyers in criminal defense work. So where does that leave the parent who's not indigent but can only afford what some would consider less than adequate counsel? Where are they left?
Your Honor, I don't believe that these rules preclude the advancement of that claim, but I would submit to you that in JB...
Well, again, I mean, let's be honest in our discussion. I may agree with that, but some are saying we need to have it in the rule so it's clear. Why do we want to litigate that further if that's the conclusion?
Because in JB, Your Honor, you asked for procedural direction on how to implement an ineffective assistance of counsel claim when raised by indigent parents. This, I believe, in a rulemaking process is not the proper process to initiate a substantive decision about...
I agree with that. I can agree with that. I understand what you're saying, but what is the... Okay, I understand what you're saying, that That would be, you're saying would it be expanding what the
Would be
group is
expanding what
authorized to do?
JD said in two important ways, by recognizing that a non-indigent parent has the constitutional right to counsel, and that a non-indigent parent has the constitutional right,
So this court has to wait until there's a case in controversy on that issue to decide.
Exactly,
That's your
so it can
point.
be fully briefed after the facts are developed and after the lawyers have an opportunity to present argument. I know the amicus briefs in JB urge this court to make a broader ruling to encompass all parents with the right to counsel, and you resisted that entree to do so, and I think for very valid reasons. And the state is not acting when a private party decides to hire counsel. The state has nothing to do with that decision. The state doesn't orchestrate that decision. The state, it's not unfair to allow that parent to hire their privately retained counsel. And I would submit to you that the broad rule siphons money, siphons time out of an already overburdened system. And when it
Well, I
does
mean,
so,
that's the doomsday kind of argument. Oh, look at all of the world of terribles that are going to come down if you had a broad rule. What data is there with regard to that? The arguments I've heard here this morning is that really doesn't happen that often.
I disagree with that, Judge, because this right, constitutional right to counsel, also exists in Chapter 63. The Select Committee did not address that because they did not feel that it was in the purview of the court's direction, but I've handled 3,000 private adoption cases, and at least 25% of those cases have had private counsel. So I would submit to you that this issue is much broader than the scope of the dependency case, where you might not typically have private counsel.
Thank you.
Thank you, Your Honor.